tax deductions. So if there are tax deductions available to you by, let's say, mortgage or maintenance or real estate taxes, who gets that?
You have to be careful, because what can happen in a mortgage document is the transfer of title could create a trigger that the bank could call the mortgage, and they're concerned about whether a transfer of title will create an increase in an interest rate.
We're usually so focused here in New York on when we talk about financial disclosure, listing all the accounts, business interests, whole life insurance, vehicles, jewelry, etc. Easy to forget pets.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers for today: Matthew Cooper, Alan Feigenbaum, and Daniel Lipschutz. Matthew F. Cooper retired as a justice of the New York State Supreme Court in December of 2021, having served for 21 years in the state judiciary. In 2000, Cooper was elected to the New York City Civil Court. He was initially assigned to criminal court for 3 years before returning to hear civil matters. In 2008, he was appointed an acting Supreme Court justice. 2 years later, he was elected to the New York State Supreme Court. From 2009 until his retirement, Cooper presided over court parts that dealt exclusively with divorce and custody cases. Alan Feigenbaum is an experienced matrimonial and family law attorney whose prime focus is the maximization of his clients' long-term post-divorce emotional capital. He assists a diverse range of professionals and their spouses, including business owners, lawyers, investors, and entertainers, on their family law matters, with a notable focus on evaluating the optimal strategies to manage and resolve complex financial and custody disputes. Daniel Lipschutz represents individuals and families in complex domestic and international family law disputes, including matters related to divorce, custody, asset division, child and spousal support, paternity, and business valuations. As an experienced litigator and practitioner, Daniel has consistently been recognized in peer-reviewed surveys as a top matrimonial attorney in New York and, more recently, Florida. In addition to litigation, he has extensive experience in alternative dispute resolution, including arbitrations and mediations, conducted locally, nationally, and internationally. The webinar presentation that you're about to watch will be approximately an hour and a half, and if you have any questions, we will be taking those at the end, time permitting, and you can submit those at any time by clicking into the Q&A button in your control panel and sending them in there. Now, without further ado, here is Matthew, Alan, and Daniel to discuss drafting divorce agreements, simplifying the complexity to achieve common sense.
Hi, everyone.
And hi, everybody. It's great to be here, and great to be here with Alan and Daniel remotely.
Yeah, I'm sorry that I'm not sitting next to you guys, but thankfully we were able to coordinate everything and get up to speed. It's nice to see.
And I'd just say we've been in the room together many, many times, all of us, either when you were before, both of you were before me at other time, as when I was on the bench. And then more recently, we had back in a very long, drawn out case, which was finally successfully resolved. You were the two lawyers before me as the mediator.
Yes, and thank you again for that, Judge. So just focusing on the title here, we're going to be talking about how we draft these separation agreements, prenuptial agreements using plain English. And really, I think that if you allow yourself to get into the weeds when you're drafting these documents, you might convince yourself that you have to be writing something in a very fancy legalese type way. And I think the more that I have done this, the more I realize that you always just want to be thinking, if a judge is reading this, will they be able to understand it and implement it with ease? And I think, at least for me, I think that should be the priority versus, wow, you look brilliant in the way that you drafted this paragraph.
Yeah, I think without a doubt that it's how I approach drafting as well. And in fact, to Judge Cooper's point, sort of the genesis of this CLE was the case that the three of us had together. It involved essentially all of the things that we're going to cover today. And I think Alan did the initial draft, and I not only complimented him, but as we started talking more about it, we now I guess having practiced close to 20 years, thought it would be a good idea to have this CLE and go through the issues that come up in drafting, complex matrimonial settlement agreements, issues that we encounter, and also from the judge's perspective, not only when he was on the bench, but since he's left the bench and been a mediator, he's successfully mediated, I think, probably a dozen of my cases at this point. And get his perspective on how to approach some of these things. But it's making sure that you when you draft these agreements, you want to be as straightforward as possible, but you want to issue spot, and that's essentially what we're going to talk about today in going through the presentation.
Thank you, Dan. So we're going to start with personal property and furniture. And I know that, we preface this by saying complex, and you might be thinking, like, why on earth would you
Is the first slide that you bring up
furniture? But I will say that it's an unusual looking couch.
The ugliest couch you could find.
Basically. I
thought this was a picture of a couch in your house, Alan.
No. That is so insulting, Dan. You know what? I'm never doing a CLE with you again. I think when we deal with these issues, right, maybe the first question is, does the client care? Before, like, as far as figuring out how are we going to draft these provisions about furniture, etc., do they care? Because if it's just, look, I want my family heirlooms, but the rest, who cares? Then maybe it's just, well, person A is keeping this house and they'll keep all the contents. Person B keeps the other home and they'll keep all those contents if there are two homes. But I guess drafting wise, this can get hard when two people want the same thing or the same things.
And remarkably, we have this as FOF, fighting over furniture, from a judge perspective, and now from a mediator perspective, I would call more fear of furniture, because it's one of those things that always looms at the end. There are certain issues you just about there.
No one wants to confront
You've
it.
dealt with the major issues. You've divided up millions of dollars, or you've figured out complex matters involving the children. And just then finally someone says, well, what about the stuff in the apartment? I want this. And it becomes a horror show. And so that is, yeah.
I mean, look, I think a few things come to mind, right? One is, we have it here, just alternate selection. I mean, it seems simple enough. I don't actually know in practice of all the times I've used that in agreement to say, look, you'll flip a coin, whoever wins the coin toss picks first, and then you just alternate one after the other. We use that a lot. I wonder if divorcing spouses actually ever do it. Do they sit there with the coin? I'm not sure.
It's a good question. No,
As a judge, if you guys came before me, lawyers came before me, there's an issue about household effects. I think the line that New York judges would use, because of the type of languages, we don't do tchotchkes. We don't do personal items. Figure it out. Go flip a coin. That would be, and that was but understanding, when such judge says that, a lot harder to implement that than it might.
Yeah, I think very frequently when we get down to these issues, unfortunately, and I try and as best as possible, and you both have seen it in my practice in cases we've had together, you try and not have to deal with it, or you leave it to the end. But when you confront it, I mean, we were talking about this earlier when we were preparing for the CLE, the starting point, I think, is what you said, Judge, is either figure it out yourself, or if you're bringing it to me, the most equitable way that I can probably handle it is I'm just going to sell everything.
Yeah.
And then what ends up happening is people incur, significant lawyer hours addressing personal property. And yeah, I think with respect to a resolution outside of court, it's coin flip, alternate selection. You pick the first one, the next person picks the next two. And yeah, I don't know. I don't think I've ever overseen the coin flip. Judge, have you ever encountered any cases where that That happened?
I think the only coin flip I've actually witnessed is at the Super Bowl. I guess, but yeah, but no, I know it has happened though. But who's that? I have had cases where it did. I didn't witness it, but it did happen.
But that does bring up a good point, which is there any law on this topic? I mean, it would be nice to be able to tell clients as you're drafting these agreements, well, we're guided by the case law.
Yeah.
But I'm not really sure that even, at least in the state of New York, are there cases about disposition of personal property?
No, I think
Maybe in a property law dispute, but I don't know about divorce.
I think the judicial default is sell it. That's always going to be sell it, and then of course recognizing that that most of the things that regular people have aren't worth much. Once the furniture that is used is worth nothing unless it's an heirloom or unless it's some sort of collector's item or some sort of antique. It always becomes an issue. Is it just old stuff that's been used, or does it have some special value? That it could be inherent value, meaning it means so much to me. I had one case where the parties were fighting tooth and nail over the last thing. It was who was going to get the wedding photo album. And I said, how could you hate each other? Why would you possibly want that? But yet, and I guess we know what happens in divorces.
And
right?
it's not enough to make a copy of it.
Yeah, right. They wanted the
Original. Yeah, exactly. No, I guess the only other point that I have on sort of on this topic in terms of drafting, one of the other things, or one of the other ways in which I draft around this, if it really can't be figured out, is I punt it back to Judge Cooper or like a mediator or something like that. Like if you really can't figure it out amongst yourselves, then go to alternative dispute resolution. And in my years of practice, every time I've done that, I can't remember a single time where they've had to ultimately go back to an alternative dispute arena to solve the personal property. Sometimes it's more about being entrenched in the fight, and when the dust settles, I think as relates to this stuff, it usually seems to work itself out.
And go ahead.
Yeah, and of course there are personal items that are far more valuable that are worth fighting about. Jewelry. How often are we seeing watch collections? Those seem to be things like I can't imagine that swatches are worth so much, but they could. And then finally, most importantly, art. Yep. And that I think takes on a whole other world of how do you decide who gets art. And when you draft an agreement, there has to be let's say if someone has a particularly valuable collection of art, and let's say it's a limited number of artists, how that art can be sold, released, because that impacts the market and impacts the value. So
I guess before we get into decorative art and fine art, if clients are saying, well, before you put pen to paper on how you're going to deal with the furniture, we need to know what the value is of the furniture, such as the couch in this image here. And I don't know why, but many people seem to have very, very valuable sofas,
Right.
even if they've been around for 20 years, they're just priceless. And I just, look, this question does get posed to us. And Dan, have you ever had, everyday furniture appraised? I have not.
I've had inventories made, and on occasion, I've had big inventories made, and the way that I've dealt with whether it should be value or not is I'll ask the expert that we've either neutrally retained or partisanly retained whether or not after their initial review of the inventory they think it has sufficient value to be appraised. That's usually how I do it. When you get to that crazy level of whether it's fighting over personal property or big collections or even odd collections, I usually start with the inventory and then kick it to the experts. I don't know if you have a different experience out.
And then I find invariably people are shocked and outraged that that it's worth so little too. They come back and say, how could that be? No,
Right.
But I found though, but in the case, very difficult case we all had, and this was the last issue that we had, by just making an inventory, going back and forth. What do you want? What do you want? And we were able eventually, by good lawyering, as we're able to impress upon them, this is not worth scuttling an agreement for. This is not worth bringing in people to appraise. It's not worth that much. Let's just figure it out. And you did, correct?
Yes. So I think just shifting to art for a moment, I just want to focus a minute on prenuptial agreements and add that putting aside a prenup, the law here is that if you are acquiring art during the marriage, right, and you're trying to figure out how does that get divided in equitable distribution, courts are supposed to look at all facts and circumstances, whose name is on the invoice, what source of funds was used to buy the art, where was the art hung in the house. I mean, it really, to me, gets ridiculous, but the law here is, per the appellate division, invoice doesn't control. And so what I find myself doing in a number of prenuptial agreements with people that think they're going to have an art collection developed during the marriage is to say specifically, no, invoice does control, and we're not going to be guided by, the appellate division's decision, first department, that says it doesn't. I'm not sure if that is an issue that's an area where you can use drafting to be creative and kind of get around the prevailing law in a way that does not, flaunt public policy.
Right. And just really one aside, since we have people who are from all over the country on this, when Alan's from the appellate division,
Yes.
first department,
Correct.
it's the middle level appeals court. And that's the appeals court that would handle appeals from where Alan and I are now in Manhattan. Right. Yeah.
Hello to everyone outside New York.
Right.
No, I listen. Again, to your point about drafting and dealing with, the starting point being what does the law say, and sometimes it could be murky, and the talking point that, as relates to this, that Alan came up with was a case he was involved in, and he was talking about the First Department Appellate Division dealing with how do you allocate artwork, and if you either get creative or specifically delineate in an agreement, this is how title will be found, whether it's not, non-marital, separate property, or marital. You can just say invoice or some other document that reflects title. And yeah, that's I think in all of my prenups, I have that delineation, that, documentary evidence spelled out for that exact reason.
Let me just ask you, Dan, when you were talking about if you've got two people that just cannot seem to agree on how to divide the personal property and you kick it back to a mediator, meaning that in the agreement, you can actually put in a clause that just says, look, as to the contents of such and such house, the parties will meet with the American Arbitration Association for up to 2 sessions, fees to be split 50-50, and that person will make a binding decision. Goodbye.
Yeah, exactly. I mean, and I realized when I flipped the page on the slide that I jumped ahead a little bit, but yeah, I think that one of the ways in trying to get finality, even when you have open issues, when you're resolving a divorce case, is through the use of, yes, meet and confer, try and figure it out. But if you can't have some either arbitration provision or mediation provision, make sure you allocate in the agreement how costs are going to be allocated between the parties. Sometimes I include provisions that say, if one party obstructs the process, that they can, fees can be reallocated, things of that nature. But yeah, it's certainly a way of creatively getting around an issue to globally resolve a case, but with the issue not technically resolved, and a means to get it done. And as I said, as it relates to this, I can't remember an instance where I put a provision like this in an agreement and ultimately the parties couldn't figure out how to distribute the personal property, such that they have.
It seems like a doubt eventually. And of course, I think, Dan, what you just talked about is there's always that pressure. You want to get it done, especially if you're in court. It's got to get done. There's pressure from the judge to get it done, and then making sure that it's clear enough that whatever you come up as the resolution can be enforced if need be.
Right.
Yeah. But what I do find, I've always found that, hey, turning this over to a special master, turning over to, we're going to hire someone who's going to be the person who's going to determine how the art is distributed, is a good way of pushing it off, but not pushing it off in the sense that, you're just going to let the issue linger. It gets done.
Right.
I think you would all agree, right? Yeah.
Yes.
Yeah.
So I think before we get into how to address pets in prenups and separation agreements,
That special type of property, right?
yes. And Judge Cooper, you mentioned the wedding album sticking out. Just Dan, what's the one artifact that sticks out for you? I mean, I know mine.
The one that people
Yes.
were fighting over, it was like a cornucopia, like sculpture of some kind that, I'll always remember that. Like I was on the phone and it's where you hang up and you're like, that was one of the phone calls I thought I was, if you asked me, will that ever happen in my professional career? And it did. And it's happened again. But yeah, that's the one that sticks out in my mind. What's yours?
Sewing needles. I can't even. I'm not going to say anything else. Okay, so for pets, I think just focusing on prenups first. I think we're usually so focused here in New York on when we talk about financial disclosure, listing all the accounts, business interests, whole life insurance, vehicles, jewelry, etc. It's easy to forget pets.
And New York's a special situation now.
Why is that, Judge?
New York was New York, the legislature, when they amended the equitable distribution law, the law that governs how properties be distributed, to include ownership of pets, but to have that ownership determined by what's in the best interest of the, I guess the term, the companion animals. So I guess that is limited to cats and dogs.
But so does that, is it fair to say then we now have pet custody in New York?
Well, we still, as I like to tell everybody, it still not shouldn't be considered custody. That term is not used. It really is awarding possession of the animal. But it has somewhat morphed into custody.
But so if it's property, then you want to think about, does that get put on your disclosure for a prenup? Because if you're saying that's your separate property, then you better say it. Dan?
I haven't yet put a pet in a prenup disclosure, but I probably will now.
Yeah, no,
Based on this conversation. And I don't know how it would land, but I like it. It's like, oh, do you have a pet? God forbid your marriage doesn't inure long term, and
a lot of
are you putting pets on disclosures?
yes, and a lot of times these
I love you.
couples already both have formed a relationship with the animal, and so when someone sees, wait a second, that's your separate property, they then want to put something in about access if there's a termination of the marriage. So
and it's unclear to me whether again, the statute talks about possession of the animal, and it used to be New York's chattel. It was determined by who was the title owner. So who bought Peaches, who bought Fido, who bought Frisky the cat. Now it's going to be what's in the best interest of the animal, which.
And listen, in drafting provisions that deal with pets, whether it's in a prenup, which I've not yet encountered, but it's definitely food for thought. But in marital settlement agreements, I mean, it's the provisions run the gambit as they relate to children, whether it's with the costs, whether it's dealing with
costs. Stuff was hard enough to figure out with kids, let alone animals. But as a dog owner, I can understand how important it is to people. And the way it was before was not correct. It shouldn't have been just, okay, whoever bought the dog gets the dog.
Right.
But it's a whole new world of offering all sorts of complexities and all sorts of areas for dispute.
All right. Well, shifting to a totally different topic now, way different. We have what we're calling here the if, as, and when assets. I mean, just to start it off, Dan, just one that rings a bell for me. If you're my divorce lawyer and I say I've made a $100,000 investment in a new tequila company, it's going to be the best tequila ever. And now you're working on the settlement agreement. How do you address my interest in the LLC that has the investment in the burgeoning tequila company?
Yeah, for me, I think this is probably one of the more important topics that we'll cover today. I mean, they're all important, but and I see it more so now that I practice in 2 states. which is the dealing with assets that you will choose to distribute if, as, and when, meaning you're not going to value it and buy someone out from the asset, the non-titled party. Or that it can't be distributed. When assets are passive in nature, and sometimes even when they're active, if the title party agrees, one of the easiest ways I think to resolve the distribution of a passive asset is if, as, and when, because it takes the issue completely off the table. When one party might say, I think it's not worth a lot of money, the other party thinks it is, and then there's all this game theory about how do you approach the negotiation. I think dealing with if, as, and when, in essence, keeping everything titled where it is, and then in an agreement, make sure that the economic rights to flow to the non-titled party. And you have to be really careful with these type of provisions. What I mean by that is, if you're distributing an asset if, as, and when, then there needs to be in the agreement, my opinion, several different components. One, ensuring that once there is distributions of some kind, and I think this is one that's also quite important, if there are capital calls or expenses related to the asset, that they get reconciled. And the provision that you draft in the agreement has a mechanism for a reconciliation. And that's very, very important, because you want to ensure that not only the income and distributions, but also the expenses, the potential liabilities, the taxes are all accounted for. And you get into, once you have provisions for periodic reconciliations, how you deal with reconciling taxes. Alan, if you want to talk a little bit about that, but I think being able to identify assets and distribute that are passive and say, let's take it off the table, let's distribute it if, as, and when, and that may be all good and well, then you get to drafting. And obviously, to Alan's point earlier, it has to be simple, but you need to make sure that when you do these type of agreements, these provisions, you have to be really careful, because if you don't,
and there's the added complication of when the asset isn't fully passive, when the titled spouse has some actual activity, has some authority as to what happens with the asset. What do you guys do with that? Yeah.
Well, so just in going in sequence with that Dan was talking about capital calls. So when you're drafting, let's say you've got these assets that you're going to divide if, as, and when, but you're silent on who pays the capital calls or who funds the capital commitments. Do you think the titled spouse is just out of luck? They have to pay 100%?
I mean, I think that you're no longer in the sort of divorce court equitable distribution mentality. You now have a marital settlement agreement. It's a contract. It's a plenary action. And if the language does not allocate in the contract, potential liabilities, capital calls, things of that nature. I mean, obviously we're talking about in the theoretical, but I think that, you might very well be out of luck. And
just if you don't say it, it's a very high danger that it's just not going to be. If you want them to be split 50-50, if you're looking for one party to advance them for a period of time, subject to reimbursement on a later date, it's not all upside. In other words, you don't just sit there waiting to collect. Like Dan said, there's taxes, capital.
Well, you must differentiate between gross and net. You have to address
It won't be spelled out, because it's going to be a problem down the line.
Right. And so when we talk about, okay, if, as, and when a titled spouse gets, let's say, a distribution on account of an investment, then what happens, right? Then you have to spell out that the non-titled spouse is going to get X% of that distribution net of taxes. And when Dan talks about the reconciliation, it's, well, maybe you do it net of what you project will be your income taxes for the year. But it turns out when you pay your actual taxes, perhaps they are more or less than the projected taxes. And depending on whether or not they're more or less, then yes, a reconciliation might be in order.
And if you want to slice it exactly correct, in my opinion, when dealing with these assets, what you have to do is you have to have a tax reconciliation after the titled spouse has filed taxes. And when we talk about tax reconciliation, essentially what we're talking about is you take your filed tax return and you have an accountant prepare a pro forma return, basically a secondary return that's not filed, and they withhold the income that is attributable to the asset that was, the income producing asset. And the difference of the tax that you pay on the tax return that you filed and the pro forma is the total tax that was paid attributable to that income. So if the non-titled spouse is going to get 50% of the income, then whatever that differential is the 50% of tax that they would be ultimately responsible for. And you can't know that. You can't know it until income taxes are filed. Now, when I'm approaching these provisions, is it 1,000% correct all the time if you're using the final tax return? It might not be, because you might amend a tax return later down the road. I don't think that I've dealt with that issue where I've done a tax reconciliation and then 3 years later there's an amendment. But for the most part, I think the cleanest way and most appropriate. Now, granted, there's costs involved because the accountant isn't just simply preparing one return. They're doing a secondary return and some type of an analysis to determine what the tax is. But it's the cleanest and most exacting way, in my opinion, to do it. And you just have to be careful when drafting these provisions that they're clear and straightforward and you understand what it is you need to do. So if you give the provision to an accountant, they understand what their task is.
Right. Now,
But
but
yeah.
the marching instructions are there.
Right.
And of course, this would depend on how valuable that asset is, if as and when. If one of those $5,000, $10,000 investments, maybe not, right?
And I think it's important what Dan says about an accountant, because you'll want it when you're drafting these types of provisions to say that, look, if the parties do have a dispute over the amount of taxes withheld, we can put the issue to a designated or a mutually selected accountant.
The goal,
I think it's one of the
as always, is to make sure it doesn't go back to court. You want to be able to have some other way of determining this without having to do post-judgment litigation.
Yeah, and I was talking to Alan, the judge, earlier today. I just had a Zoom conference with a couple of younger lawyers in my office talking about this exact issue, because I think that from a matrimonial practitioner standpoint, being able to take an asset issue off the table by simply saying we're going to divide it in kind, but it can't trade, or as if and when in kind. In other words, you're not going to transfer title. It's a hugely valuable knowledge piece that will allow you to get through some of the more complicated matrimonial cases. And then obviously you need to draft it, but it takes all the fighting out of it. It doesn't matter what the value is. It really doesn't.
And it saves a lot. Let's say if you do this, a lot of times we've seen people with 100 of these private investments, and each one is not worth a huge amount, but then each one would have to be valued by a forensic evaluator, which would, and that would cost probably more than some of the assets are worth.
Yeah, and like putting a pin in it a little bit, or taking it a little bit further, there can be some concerns if there is control by the titled spouse, not necessarily in the income stream itself or the expenses and potential liabilities, but control of the business, and if they are agreeing to distribute an asset if, as, and when. So, if you encounter that concern, usually what I do is I call, any one of a couple of corporate lawyers that I have as colleagues, and, I buy 30 or 45 minutes of their time and ask them about it. And sometimes they have ways of drafting language, but for the most part, I believe with an appropriately drafted agreement, you can address any of those concerns. Alan, you agree?
I do. I guess, if you've got someone who actually has some control, the question is posed, well, Dan alluded to this, if, as, and when, but I don't know if so-and-so is going to intentionally try to dilute the value.
And hey, remember that often the non-titled spouse, there's no person who he or she hates more.
Yeah, there's no trust
than the person,
Right.
who's soon to be the ex-spouse, who is going to be the titled spouse. So that you have to then come up with guardrails to protect and convince to assure that non-titled spouse, the part that the titled is not going to, it's not going to be permitted to act in a way that's contrary, has a duty not to act in a way that's contrary to your interests, and that you get notice of everything that has happened.
And one other, for me, on this issue, one other point, practice pointer. If perhaps the subject matter of the marital estate isn't as significant, but you're trying to distribute an asset if, as, and when, one way of making it a bit simpler instead of having to do a tax reconciliation is you just pick a tax rate. Whether it's a long-term capital tax rate in Florida because there's no state taxes, you're just dealing with federal tax. In New York, you're picking perhaps local and state and federal, and you just basically say if there's you have to do a reconciliation of some kind to show me what's been paid out, but we're not going to go the extra step of having an accountant have to perform a pro forma tax reconciliation. We'll just pick a tax rate, and that's simpler in certain instances, and you just put that into the agreement.
And I think I've seen that more often than other methods.
Well, let me ask you, because you brought up, look, it might be a futile effort to value these interests, right? But we've seen the law, at least here in New York, that you see cases that say, look, if you didn't prove value, I've got nothing to distribute. So I don't know, at least in New York, if you can depend on if as and when is great for a settlement agreement. I'm not sure how that plays out after a trial. I'm not sure you can bank on that and come in with no value, even though I think it's still very sensible with as and when.
You can, you have to be really careful, because the minute you show any active effort, in my opinion, any active effort, it takes it out of if, as, and when. I have successfully received an if, as, and when distribution from a court without a value, but it's super risky. It's super risky. And I think that, if the other side hasn't valued, the way to take it out of the if, as, and when sort of court's equitable ability to distribute it in that manner would just try and find some active component. My opinion. That's just how I've encountered it.
Real estate.
All right, so we're moving on to real property now. Although I suppose a New York cooperative apartment is not really real property, and God bless. That's not plain English. Okay, so
Things that make you smile, Alan.
it's too much. I've been scarred forever. All right,
The sofa and in cooperative apartments.
it's going to get worse as we go on here, Dan. Okay, so we were just talking a lot about tax issues, right? So I know that we as matrimonial lawyers deal with these tax issues a lot, but now you're talking real estate and transfers of real property. At some point, we know how to draft these clauses, but you do kind of need to get a real estate lawyer involved, at least for the actual closing documents. But as far as the separation agreements go, a few things, one of the things we wanted to talk about here is when you're dealing with transfers and co-ops, yes, it's not a given that a board is going to approve a transfer from joint names to sole name, particularly if the transfer is going to what we call the non-moneyed spouse. And but you can, again, here's another situation. You can draft around that. You can anticipate, well, if the board denies, here's what's going to happen. In other words, non-moneyed spouse is still to be deemed the full equitable owner. Have you ever had a situation, Dan, where somebody was actually denied, like the board said no?
Yes, I have.
How did you deal with that?
Well, I think similar. I mean, I was smiling to myself when you flip the slide, because each one of these topics, when you think about approaching drafting a matrimonial settlement agreement, there's like a laundry list of things that come up that we probably think is almost second nature. But when, to talk about it, I smiled because they're such broad topics. But to answer your question directly, it's similar how you deal with refinancing. I think you have to build into an agreement protections to, especially with real property, to deal with situations where perhaps, as you said, the co-op board denies the transfer. You aren't able to refinance a mortgage, or you aren't able to take a person's name off of a mortgage. Any number of things, or if there needed to be a certain amount of money paid to the other spouse to be bought out at some period of time, that doesn't happen. I think I very frequently in matrimonial settlement agreements am dealing with the contingency on real property, and it has to be sold.
The contingency is going to be the property sold. That's always the default.
Right.
Not always, but very often.
Well, but I guess especially in this climate, with interest rates being what they are you seeing more, Dan, couples that want to have agreements that say, look, let's not mandate a refinancing in 90 days because then the rate is going to skyrocket on a mortgage. So let's just provide that a property is going to, continue to be jointly owned with the existing mortgage. And that, by a certain date, there'll be a refinancing, but perhaps beforehand a refinancing only if you can get a comparable rate to what we have now.
Yes, and as you're saying that, Alan, I'm thinking about how, because the three of us have been doing this so long and we're speaking our language, perhaps the viewers out there aren't necessarily at the
Because I think they understood capital commitments.
No, right. No, but I what we're talking about is if a person, let's say you have a joint mortgage, two people are on the mortgage, or the person that's being bought out of the residence is on the mortgage, and the person that is remaining in the residence is going to take over the mortgage. Almost always you want to create a situation that the person that is not receiving the residence is removed from the mortgage, because the debt is in their name. If any number of things can happen as a result of that, and have far more ranging implications down the road. Customarily, in the way that I approach the refinance or taking off of debt, you have to be careful, because what can happen in a mortgage document is the transfer of title could create a trigger that the bank could call the mortgage. And with interest rates being so low previously, a lot of people have great mortgages, or they'll come to us and they'll have good mortgages, and they're concerned about whether a transfer of title will create an increase in an interest rate. So we deal with that. And I think it's something to understand in drafting the provisions, but also whether or not you want to build in protection about the transfer of title. And sometimes when I'm not the person that is receiving the residence, I don't care too much about it. I want my client off the title. And if there's not a mortgage contingency of some kind built in, I think it's on the person receiving the residence or the real property that they might have a concern. You follow my flow a little, Alan? I mean, I'm sort of, he is explaining it as straightforward as I.
No, you're bringing something up, which is if you have a case where, let's say, husband solely owns a house and title is transferring to wife, and husband is representing in the agreement, look, other than our mortgage, there are no other liens on this house. As a matter of practice, do you do a title search on the house to see if there are any other liens? That just came to my mind because I can think of one case where a title search uncovered liens that we didn't know existed, but that doesn't, usually you would hope that people are telling you the truth.
I don't.
I remember it.
Yeah.
I don't, but it's good.
Yeah.
It's good. But we build it into, with that too. I mean, another thing, you can build into an agreement.
Liens, right.
Undisclosed liens. But because I remember your provision in particular on the real property, the way that we dealt with it, and we kicked, in the case that Alan and I recently had, we kicked the sale way down the road. Right. When you approach drafting a real property provision, how do you go about approaching it? What's your sort of checklist? I know I'm putting you on the spot because it's not something we talked about before, but honestly, your draft is, I don't think I had like 3 changes.
No, but so look, one, okay, who has possession of the house? Let's start there. Let's please not forget to say who can, because God forbid you don't put that in, and then, I don't know, wife is living there and husband just shows up and I'm just going to make a sandwich. Like, this is not, and then, your client's calling you, what the hell is this? Well, we forgot to put in the agreement that you have exclusive use and occupancy of the home. So start with possession. Then there is, like Dan was saying, the title transfer, but making sure that even though you're going to lay out in the agreement by when the title transfer has to happen, you've got to have language in there that says, look, when we sign this, for all intents and purposes, so-and-so is the de facto equitable owner, notwithstanding the title has not changed yet.
Very important provision.
Right. And there's also, you got to talk about there's a lot of costs with title transfer, right? So probably going to be, at least in New York, a real estate lawyer involved. Who's going to pay for that? There are going to be transfer taxes, New York City, New York State, mansion taxes.
And if you have people living out in the Hamptons, which a lot of
Yes.
New Yorkers here know about, there's a significant tax that's imposed.
And as far as I understand, you can't get around it. That's a question that's frequently posed.
People often think, people will often, I remember I always heard when I was a judge, people would say, oh no, you don't need to pay a transfer tax. It's
a transfer tax.
not true.
In New York, there is.
New York, you got to do it. Right.
But I think it's incumbent as you're drafting this to find out from a tax specialist, what would the taxes be based on the appraisal that you probably have, whether you're negotiating a settlement or not. You probably have had the residents appraised, so that you have a sense of, well, what does it mean to say that's split 50-50 or it's paid 100% by one person, right? Then I think, again, just to come back to where we started, you do have to address contents. Can't forget that. And I also think someone alluded to this, which is if you decide that you're going to keep the mortgage in place for a period of time, but let's say the person who's getting the house will pay the mortgage, right? But the other person's on the mortgage and they default.
How do you protect them?
Right. So how many default payments do you allow, which are not cured, before it's immediately put on the market and listed?
And all that has to be spelled out. One quick question for you. The idea of assuming the mortgage. People sometimes talk about the mortgage assumption. I rarely ever see that. Does it happen? The banks allow that when it's 2%, 3% mortgages? Yeah.
Yes. You always hope, well, like, you're in the private wealth group. Can't they do you a favor? I have not seen that yet.
Yeah, I don't see them releasing people off mortgages.
No, when you hear about
almost ever,
it's prohibitive.
Yeah, it's kind of how everything changes rapidly. When I retired from the bench in 2021, mortgages were at 3%. Now, in my mediation life, mortgages now are nowhere near.
So I was going to ask you, Judge, is that coming up frequently in the mediations that they're dealing with the desire to keep the mortgage rate in place?
Absolutely. When one party if the house isn't being sold, one party is going to buy out the other party or receive the property as part of the agreement. That's always an issue. And one of the things that often is negotiated is how long is the other spouse willing to stay on the mortgage?
Right.
Yeah. And often that's, hey,
it's become an asset. I think it's all it's an asset. Quite frankly, it's an asset.
Yeah, absolutely.
There's also, I think you need to think about a provision about, at the person who is awarded the home, so to speak, if they decide in the future to sell it, to be clear about, well, then that person's paying the capital gains taxes.
Right. Yes.
Right?
Who gets it?
You can't forget what happens if there's a sale and there's capital gain. And then also want to get into tax deductions. So if there are tax deductions available to you by, let's say, paying the mortgage or maintenance or real estate taxes, who gets that? You don't want to forget that either.
No, that's when you went through your checklist, I was thinking to myself, it was very comprehensive, and
it's crazy how these things.
You just said no, but you're right. But that extremely important. Capital gains tax, and if there's an ultimate sale, how that's allocated, and also the whether who takes the mortgage deduction.
Let's just talk about one other thing since you raised the Hamptons, Judge. And that is, I think before you close these agreements with real property, you got to find out from your clients, are there issues with the C of O, the certificate of occupancy? Because maybe you put an outdoor shower or sauna or a gym in a garage and you never got a certificate of occupancy. You got to look at the local rules in the jurisdiction where this house is and find out, well, is your client going to be able to sell it and with a defective C of O? Because the answer may be no. And so then you better figure out before you sign an agreement, who's going to pay the costs to bring this thing up to code.
And that's sort of in line with that is what a realtor will come out and say, this is house, I can sell this house for $3 million, but
yeah,
you need to repair this, this, and this. You need to stage it. You need to repaint it. Who pays?
That's the last thing I would say. Go ahead, Dan.
Yeah, you raised another point about the sale process, and then we can move on. But I was involved in a case many years ago where there was an agreement that had been drafted that put a piece of property on the market to be sold, but one of the spouses remained living there until it was sold. And they did, and the market in the area changed, and there wasn't a step down provision in terms of the sale price, and you can't modify that. So in essence, you're out of luck. So very important when drafting sale provisions of real estate that in the event the listing price is set and it doesn't sell, there needs to be a trigger in your agreements that the price can be reduced, because it can be used as a way of the person, who may be in the residence to mess around with the sale process and delay it. And I think that
a clear mechanism
definitely have step downs. Really important. Sorry, I know
No, go ahead.
Oh, I was going to say, this, and you're going to have problems with the sale, with what's going to happen with the sale of the real estate when the parties can't agree on who the broker is going to be.
Yeah.
How often have you seen blood being shed over, that's my broker, not her broker, that's his broker. And I always tell everybody, hey, a broker has one interest in life: selling.
So you're probably
For much money as possible, that's all.
And I think
Stop it.
two last things here, just whether it's a sale or someone's keeping the home, you've got to say who's paying the expenses, and does that include repairs, like Dan said? And also one that I think is very important is designating the agreement. If someone's taking over all these obligations, you want to be clear that all the bills are current up through the date of this agreement, so that you don't have a situation where someone's taking over all the bills and then you find out, oh my God, there's like 6 mortgage payments that weren't made. Not a position that you as a lawyer want to be in. And that's just the last thing, which is that if bills have to change from one person's name to the other for the house or the apartment, better address that too. Don't just expect your clients to do that. You actually have to spell out by when the bills will be changed from so and so. I know it sounds tedious, but you literally get down to things like a Verizon bill.
Yeah, and I think we've addressed probably 90% of the things that we see. I don't think we got all of it, but large measure what we just talked about is the perfect segment in how to draft those provisions when you want to make sure that you cover the all of the different permutations that may come up.
The other things that you think might not come up.
Right.
Right.
So then we get into a really tough one, I think, which is, as of what date do you divide bank, brokerage, retirement accounts? And we seem to always have this argument: do you just divide them with their balances on the date of distribution, present day? Or do you divide them as of the date, let's say, that a divorce action was commenced, or let's say on the date that someone executed, we call it a cutoff agreement, an agreement that says, even though we haven't filed for divorce, we're going to agree that, if a divorce action is ever started, it will be as if it was filed on a prior date. And Judge, I just feel like this comes up in every case, and it just gets more and more aggravating. I don't know what the answer is.
No, and there often isn't an answer. It comes. I saw it all the time on the bench. I see it all the time mediating.
Dan, do you view it as a rule of thumb when you're drafting? Okay, bank accounts tend to be the hardest ones, because those are the accounts where there's a likelihood that there was a lot of spending and activity during a divorce case.
There's so much mischief on personal bank accounts that can be created. And in my opinion, the only real true way to do it correctly is to perform some type of analysis as to what was spent and allocated. But that rarely happens, I think. I mean, not rarely, but infrequently it happens that you'll go to that detail. So I think to the point of drafting, before you sign the agreement, have a conversation with your client to check the joint account or check the accounts to make sure there hasn't been some withdrawals or transfers of some kind, because again, we come back to, once you sign the agreement, you're going to be guided by the what the agreement says, and you're not necessarily going to have a judge to say, well, the judge will have to interpret the agreement. It's not going to be the equitable arguments from before. So, yeah, I think date of distribution, meaning doing it upon execution, customarily how I do it, unless you're doing some type of true up in values and that there's some payment that's being made to fully reconcile everything.
That definitely, it's a huge.
There's nothing. I mean, when I said judges really hated dividing up furniture, all judges I know in the matrimonial world hate doing reconciliations of what. And I know that is enough to make them say, I want to go with, I think I'm going to leave this and go and start doing
Yeah, but medical mal or something. Yeah. How many different bank accounts? But I guess, Judge, that's kind of what you're doing when you're writing the decision, is you have to go back to the exhibit and make sure that the bank balance is correct. I mean, it's what
that's, but there's all different reasons, of course, why bank balances will change. Let's say that's what the family's living on. And let's say you have a case where, all right, there's not going to be a pendente lite order. There's not going to be a maintenance or child support order. Instead, we're going to maintain the status quo and expenses will be paid. Often that money comes out of those accounts.
Right. And so, I mean, Dan is raising a really important point, which is that, let's say you're settling a case and 2 years ago, each of your clients did what we call in New York a statement of net worth. They divulged all their accounts and the account balances as of 2 years ago. And now you're doing the settlement agreement. God forbid you forget to find out, well, what's in the accounts now?
Yeah.
I mean, I just, I feel like.
Well, to that point, because I was looking through the slides, we're going to talk about brokerage accounts, but I didn't see, and correct me if I'm wrong, there's not a separate section that we're going to talk about retirement accounts, Alan?
No, I actually just wrote that down, but yes, so feel free to bring it up.
So, by the way, that you can get hurt. You can get hurt big time if you don't draft the retirement account provision correctly. I think if, retirement accounts, if there's been post-commencement contributions, you need to carve those out. And you need to carve out not just the post-commencement contributions, but any investment experience that is attributable to those post-commencement contributions. You can't just say the retirement accounts are going to be distributed date of distribution. Whenever there's an ultimate divorce and you have a quadro or a rollover, you have to be really, really careful when you draft retirement account provisions that you carve out any post-commencement contributions plus any growth, appreciation or depreciation on the post-commencement contributions. Otherwise, it's all it.
Right. And with retirement accounts, sometimes I've seen agreements where it'll say the marital portion, and they don't define marital portion. You can't leave that to the reader doesn't know. So yeah, maybe someone had a retirement account on the date of marriage, so there's a portion that is separate, but you better spell that out. Otherwise, what is a judge supposed to do with that?
And I've had that call where a client's called me and been like, we're going to distribute, like, do we carve it out? And I'm like, I'm very happy to say that we did, because if you don't, I've also had the call where my client was receiving the money and they didn't carve it out, and it's a relative windfall. Not that it wasn't appropriate, but you just have to.
Yes, about your reconciliation, Judge, again, just in New York here, Court of Appeals law, the absent fraud, the court is not going to question every debit and credit during the marriage.
No, you have people come in and say, well, I paid for that. Nope. During the marriage, we don't go back and say, you get a credit, a debit. Doesn't work that way.
Yeah, Mahoney Buntsman has had a
Mahoney Buntsman.
application.
All you New York attorneys out there, I'm sure you But yes, we're all there.
come up over and
Yes, it comes up.
somebody didn't get the word out about Mahoney Buntsman. We need Justia to get the word out about that case. So
And you are bound by what you represent in your tax return, right? So that's
another one,
you know.
right? All right. So I think on this, Dan, do you come across a number of cases where people kind of use a loan margin account to kind of fund the lifestyle? In other words, there's always this loan margin account. It's collateralized by the brokerage accounts. But then you get down to it in a divorce and it's like, wow, we have millions of dollars of debt.
And that's why you call the
Way more now in this high interest rate environment. I'm finding that the use of a line of credit against brokerage account assets are being utilized frequently because you have your private wealth manager, the person that's managing your money, say, well, we can give you a better interest rate if you take out the loan against your own assets than you could if you went and got a personal line of credit or an additional, second mortgage or something like that. So I see it all the time, and you have to account for it. And you have to be, and yeah, it's you make sure that you look at the account statements. It's not just for the.
That's not just another account, right? And also, when you're drafting, if you're saying, look, within 30 days, these brokerage accounts will be divided, you want to be clear, like no more drawdowns on the loan margin account pending the distribution of the actual accounts.
And also, how is it going to be dealt with? Who's paying that? Who's paying? Oh, great. We're dividing up I'm getting $500,000 because it's $1 million in that in
Right.
stock.
Not
Then
really.
it turns out, surprise.
Right.
It's not.
You also have to deal with managing the debt too. Yeah, because there's usually a monthly payment associated with the line of credit. But so I smile because in kind, it goes back to like when I was talking about as if and when, it's the little things, I guess, in the practice that, why we like doing this. Like maybe I'm weird. But again, on the in kind, it's the safest and most appropriate way to distribute assets that may have embedded capital gains. When I say embedded capital gains, I mean where you have investments in perhaps the stock market that have appreciated but have not been sold. And so there are unrealized capital gains. And when you're dividing brokerage account assets, you have to make sure that you account for those potential tax liabilities when and if the stock is sold down the road. And dividing in kind essentially means that you're going to divide the asset such that the cost, it's an equal cost basis.
And I find that you can bring on an expert, you bring in somebody, a broker who will be able to, who know they do this routinely, will come up with, all right, you get one low basis, you get one less, you get one high basis, you get one high basis. So it's done equally.
But again, important to put that in the agreement, because if you're saying it should be divided with, basis as close to equal as possible, if you omit that, and let's say it's husband's brokerage account and it's to be divided, and husband calls his broker and just says, all right, give her all these, I'll take those, just saddle her with all the tax liability. Like, so again, protective, but you better put it in there.
And you got to issue spot it. Especially on brokerage accounts. Embedded capital gains can really significantly change the net value of the brokerage account asset.
So we're turning our attention to a different topic, marital waste or dissipation of marital assets.
Let me just say what I'm looking at when I saw your slide here, Alan.
Yeah.
With that again, now I
That's
see it.
the Monopoly house.
Yes. No, I actually thought initially it was a lipstick, which would, because let's face it,
A dissipation.
what do you most often hear in marital waste? What is the claim you'll hear from your
Money spent on boyfriends and girlfriends, for sure.
Yeah.
So before we get into the drafting, have you ever had to adjudicate the issue, Judge? Is it ever really, because this is another one where I know there's law on it.
Yeah.
I mean, I feel like you run into the same cases over and over, but you keep coming into the question, is there a threshold?
Yeah. And I think it has to be significant.
It's a great question.
Normally, I'm as a judge, all right, money spent on dinners, money spent on small trips, money spent on small gifts. No, that's we're not going to look at that as being significant enough for marital waste. Might make you feel bad. It wasn't the right thing to do, but it's not going to change the how the case is approached. But if money was transferred, if let's say a house, I'm saying, or a house was purchased, or let's say a spouse paid for the schooling for the paramour's children, things like that would be that for me, it has to go to a level that it's significant.
I mean, look, Dan, is it as simple as when you're drafting the agreement, if you and your opposing counsel have agreed, look, there's going to be some sort of payment in this agreement to account for marital waste, you just say, look, as in for a further a tax-free distributive award, husband pays wife X $1,000, goodbye. You don't need to get into
No, that's how we're.
yeah, you don't.
Yeah. I mean, that's how it's normally. Dan, I think it's it. That's as normally as okay. Give you an extra $100,000. All right, take care of it.
Yeah, it's marital waste is an interesting issue. And I see in Florida, dissipation, they look back 2 years, although the court can go back further. New York, there's no limitation. But I encounter dissipation much more significantly in my Florida cases than I did in my New York cases.
It's Florida's all right.
It's not a knock on Florida. It's making me smile, but it's definitely way more prevalent. It's one of these issues that can, some people can be very focused on it, but it's a question of how much of your resources you want to allocate to try.
Yeah, and it's show. Well, I mean, for another one, what about bad business decisions?
Oh,
I mean, it's a different type of. I got somebody.
right. I thought we had all this money.
Yeah. Hey, and you were playing. I didn't know you were playing the stock market with that, and you lost all this money. Is that marital waste, or is that a expenditure of marital funds?
It's a tough one. I usually say you ride with your spouse, you die with your spouse when you're making those type of business decisions. I mean, rarely will somebody be that in the dark that they had no idea what was going on. They have to have known something, but you're in for the good, you're in for the bad. It's a tough one. I think that's probably even more of a difficult issue to prove up than the dissipation stuff you were talking about, Judge. That's my opinion. I don't know, Alan, if you just
Rule of thumb, I think that's right. And look, maybe one spouse decides during the marriage, hey, I'm going to open up a restaurant, or I'm going to start a new company. I don't know, doing whatever, but it turns out to be just a terrible financial decision, and millions of dollars are lost. And then you look back and say, well, we had this, now we have that. It's your fault.
Okay.
But again,
I think actually what it might come down to is the rare instances when it's looked at as marital waste, as Dan alluded to. Did the other spouse know it? Yeah,
right.
When it made some really some high risk venture that should have been done, that should have been noticed, and it's done without notice, then maybe
There could be consequences.
that's the consequences. Right.
And you also, I think it's the timing, the proximity to the divorce filing is important as well. I think if it's
Actually, let's talk about that for a minute, Dan, which is in prenuptial agreements, when you're drafting them, do you put in provisions to say that, to create some sort of presumption that if, I'm trying to there's too many things going through my mind.
Yeah.
Sometimes I'll have provisions in there to say that if someone improperly uses or makes a transfer, within X years prior to filing a divorce, it's not necessarily presumed to be in the ordinary course. I can't, without looking at the provision, it's escaping me. But I don't know if it has to do.
I've used those type of provisions when you talk about what I call downside protection.
Oh, wait, using separate property to pay down a marital debt.
Right.
So, because or to pay marital, because if somebody, is saying like, or I'm sorry, it's the reverse. And it's been an exhausting week. No, but I'll let you go, Dan.
I was going to say that the times that I've used like the improper transfer is more when I build into an agreement, a provision, testing net worth. In other words, if I have a large, my client is receiving or will pay pursuant to a prenup, distributive payment, depending on the length of the marriage. Sometimes you put into the distributive payment section what I call downside protection, which is that, that distributive payment, if it gets large enough, won't be greater than X% of the payor's net worth. And then you have to define what net worth is.
That's it. If you're using, if somebody says, I'm going to deplete the marital assets to pay off my separate debt, at some point you probably want to put in the prenup, well, if that's going on within a year, 2 years, 3 years of triggering the prenup, there's going to be a dollar for dollar credit back to the party who did not.
Yeah, I think the concern that you're raising, as I would view it in the context of drafting a prenuptial agreement, is just if by some mechanism in the agreement you're testing, what the marital estate is or what the net worth is, that you build in a provision that not only it defines what the net worth is, but that adds back certain things like perhaps transfers to trust or a dissipation of some kind with a period look back. Yeah, that's where I encounter it. I don't know if that's where you're going.
Yes.
Yeah, I'm picking up what you're putting down. Alan, you and I, we
got there.
got there. On the same room.
When we can have a whole separate section on separate property, on trusts, all these. There's only so much we can do today, right?
Yeah, that's exactly. I don't even think we're gonna get through. Alan was like, "Oh, 90 minutes would be enough."
So we go. We're going. Dan, what would go for what? 600 minutes?
Do part 2.
Right.
Yeah, 100%. I love it. It's good. That's what always happens. We haven't had our usual playful banter this time, though. If we were in the same room.
No, well, it may be because I don't know what's going on with this slide here. I look back on it. I don't understand what's happening here. But
your picture selection on these slides is top class. Like every time I flip a page, I'm like, Alan, I don't know where you went to find this, but it really puts a smile on my face.
Yeah, that's good.
I wonder if they're sitting on the same sofa
I don't know. They seem to be working it out.
from the sofa from the first slide.
Right.
Yeah, what is this?
Well, we're shifting to the topic of drafting custody
Which
provisions.
is in many ways could be harder, and in many ways more serious. I mean, there's just money. This is the most important thing you can deal with. What's going to happen with your kids, and
I just
The very tick-shakes.
there's a lot you could do what I would call the cookie cutter approach, which I don't recommend, which is when you're drafting these agreements, if you're operating under the assumption that, well, okay, there are what we call major decisions about, let's say, education, medical care, summer programs, college, what have you. And if the parents can't agree, then they'll put the issue to a parent coordinator and they'll make a recommendation and it'll be implemented, but doesn't necessarily work with every family. Some families don't need that.
many families are able to make decisions very easily.
Very early on in my professional career, the way that I learned to talk about the drafting of custody provisions is now you've been through potentially a long litigation or a long negotiation, or even if it wasn't that arduous, you're drafting an agreement and you're putting in the agreement how you're going to make decisions with respect to the children. You should not have a provision end with, if they can't decide, they go back to court where they just finished. I think when dealing with decision-making protocols, assuming there's joint custody, and one parent isn't making the final decision, I think that when approaching these provisions, there needs to be some dispute resolution mechanism, whether it's a consulting professional, whether it's a parent coordinator, whether it's mediation, something that says if you reach an impasse, there's a way to break the impasse instead of having to go to court. That's going to subscribe to.
Yeah, the idea is to avoid, but you have to remember, at least in New York, there has to be the opportunity to go back to court, because
Yes.
no matter a third party doesn't get to make the decision. Absolutely, third party can make.
Right. So you can
have
draft
to
it.
be able to, it has to be subject to some form of judicial review, but the goal is to make it as seldom as possible and as limited situations as possible where you'd end up back in court. Hey, You talk about things changing. When I first started this business, when I practiced matrimonial law, basically one parent, generally the mother, would have the decision making. We now are in a world, I think some of the people out there from other states, it's actually statutory presumption that there will be joint custody, joint decision making. And although New York doesn't have that presumption in the law, it is certainly moving towards it. Certainly judicial decisions tend to be in favor of parents having joint decision making.
In Florida, we have a law now that says the presumption's 50-50.
Yep, that's the law there now. I didn't
Yeah,
know.
and to overcome it is, it's almost, I don't want to say almost impossible. It's very, very hard to overcome the presumption of 50-50. But we're speaking New York. Yeah, it's the trend. But to that point, the trend is definitely moving towards equal 50-50.
So I always say, it's, you get these parents who barely communicate, but yet they're going to have joint decision making, and then say, how are they going to do it? And then I said, that's why God created parent coordinators. A parent coordinator being somebody who they've only a person who people put in the agreement, either a lawyer or a mental health professional, who then can be the tiebreaker. I think that is one of the most frequently used.
One thing I would say is if you have one parent that's really obstructive and you're doing an agreement with parent coordination, make sure that you're putting in the agreement that one person can't just fire the parent coordinator. Right.
So, by the way, full circle as to how we came up with this lecture. In that case that we've been talking about, not only did we have a parent coordinator, we also used a family therapist as well. In the more contentious cases, I certainly subscribe to it. You should use the professionals to guide the family as best as possible through it. Because a judge, the court process, unfortunately, even though the jurists care, no doubt, and want approach their job as best as possible, that they're just not equipped to deal with families on an everyday basis in the way that if you go into like a parent coordination process, or as you said, Judge, some type of family therapist, child development specialist that you can work with. I subscribe to it. Alan, I think you do too. No, that getting people into that forum as a means of resolving disputes.
I do. I don't, I think you just know in your gut from having done this so long, is this a family that actually needs this or not? And many couples do not. So I don't automatically assume, well, we'll need that. But to the judge's point, you can write in your agreements, look, parent coordinator will issue a recommendation. As long as it aligns with the view of one party, it'll be implemented. But the other party has the right to go to court and seek a stay. But if, pending that decision, the decision's implemented, because you have to know that, look, we got it. Sometimes you really need to make a decision, especially if it's a medical decision.
Do you use a program when approaching parenting provisions, Alan, to like stick in what it looks like with the weekends and the holidays? Do you do that?
So what do you mean by that? In other words, like, are we talking AI or?
No, basically where you take with a prospective schedule and you plug it into a program. I've never done it, but as we're shifting to talking about parenting type divisions, it's, you have to be careful, because when you're dealing with regular schedule, holidays, summer, 3-day weekends, all that there could be a lot of conflicting components to it, and that you need to build in when focusing on parenting time provisions. You have to address the conflicts. And sometimes, I think Sophie uses a program. I don't think I have, but to sort of see where
Sophie is.
My dog is named Sophie. I don't think that's what we're talking about. We're talking no, but we're trying to another distinguished lawyer.
What Dan said is right. In these their parenting provisions, a lot of times you'll have conflicts between holidays or special occasion days and the quote unquote regular schedule. You need to draft around, well, what do you do if there's a conflict? Just one more thing about the parent coordinator. If you're going to be asking the parent coordinator to weigh in on mental health decisions, make sure that you're drafting that the parties will be required to execute any HIPAA waivers that are needed, so that the parent coordinator can actually talk to, let's say, the psychiatrist for the child and actually get to because that is a tough spot for a parent coordinator who's probably a lawyer to be in to make a mental health call.
Right. And then you actually have to make provisions as to who the parent coordinator can deal with, can reach out to.
Yes.
Yeah, well,
And they have conversations with the parties separately and together.
The whole question of can they be called into court to testify? And of course, how are you going to pay for it? That becomes another flashpoint.
And that's you want to talk about, look, is the recommendation admissible in court?
Yeah.
But
There's so much under the custody umbrella. We could probably do a whole segment on just custody.
we could.
On a favorable note, on a positive note, the process does work pretty well. As a judge, I would see cases that were settled with parent coordinators in place. I very rarely saw them come back.
Mm-hmm.
Okay, they worked out even with.
There are the outliers for sure. I think in large measure, once you get a good person in that role, I also, a last point for me on this, I usually say when when you have these type of provisions, parent coordinator, or you're a consulting professional that's going to make some type of recommendation, there will be a couple initial times that you have to utilize the provision or go to the PC, and then it sort of peters out. You sort of get into a flow. You see how it's resolved. You see the process. It's a good way of getting people, used to this new parenting and post judge.
I do want to answer the judge about the limits of the role of a mediator in custody, but no, I'm not going to say more interesting. It's not that. It's just that we want to talk
about some other things.
The maintenance guidelines.
We'll do that
for alimony.
Yeah, next time we'll do mediation and custody, right?
And when we talk about alimony or maintenance in New York, it's amount and duration. How much per month and for how long? And in New York, we have these quote unquote advisory guidelines as to how long maintenance should last depending on the duration of the marriage. And I know we called an advisory, judge,
but the view from the bench, as soon as they came out, they were regarded by judges as not advisory but mandatory. They were prescriptive because when the courts they look for something that can help make decisions, and but there are cases where once in a while you should deviate because it doesn't make sense. I think we talked about this before. The case where people have been married for 40 years, giant long marriage, but after year 5 or 6, they actually separated, never had anything to do with you. They just didn't get divorced. Bring a divorce? That's like going to be shouldn't be a 40-year marriage for.
So I think that supports making them advisory, because if you do you may have to tailor it to the fact.
I think courts and saying the opposite would be if people lived together for many, many years, had the same as if they were actually married, then end up very short marriage. Do you increase the duration? But those are the exceptions. I think you're going to see the courts most often than not are going to look at those advisory durations as being something that judges are going to look at as something they have to follow. But I think everyone should be aware that there is room for some form of deviation.
And when you try to figure out duration, and I know this isn't necessarily drafting, but should you ever be considering whether or not there was a joint household before the parties got married?
Yeah.
According to our law here in New York, on paper, you're at least supposed to consider that.
If we consider it. Right. And I think it's come not often, but I think did have cases where I said, maybe this should be a sort of case where this is the type of case where we should at least consider extending the time.
So Dan, when you're drafting these provisions about alimony, maintenance, I know we talked about, duration, there will be an endpoint, but what other quote unquote termination events are there that you draft in the agreement?
Yeah. And I was, looking at the slides and giving them the timing. I mean,
we need to.
Doozy taking it, but he didn't do this for 2 hours.
We need some time for the questions, right?
Yeah. I'll finish
3 minutes.
Yeah. With maintenance, it's really the termination components, whether it's cohabitation, whether it's remarriage. I think you can have big fights, and you can get into very complicated drafting around the definition of cohabitation, how it's triggered, whether or not once it's triggered, who has the right to, whether there's a right to stop paying, or that you have a, whether you have to wait until a court weighs in. But I think, yeah,
I was
largely.
going to say, yeah, I'm sorry. Just
No, go ahead, Judge.
my 13 years doing divorces, I think I can think of just one instance where somebody was able to come in and prove that there was cohabitation.
It's hard.
If you know what you're doing, you can prevent it. 90 days, on 89th day, you go stay somewhere else. It's very difficult to prove.
Yeah, economic relationship, things of that, and it's so in dealing with alimony, that's it's how it terminates, making sure that it's paid on time, those type of things.
When we talk about clauses in these separation agreements or custody agreements about introduction of significant others to children, and look, some couples, again, don't need this. Many do. And for the ones that do, you're talking about writing in, okay, does the introduction not happen for a period of time, be it 6 months, 8 months, whatever it is? And then when the introduction does happen, do the parties have to agree on the introduction? Do they have to meet with a therapist to talk about how the introduction will be made? I think I saw something recently that, like, both, like, the party, like, let's say someone, a husband, they're now divorced. Ex-husband is dating someone. Ex-wife has to meet the person first before they're introduced to the. I mean, you really can go over, I think, overboard with this.
The richer the people, the more complex they make this. It means that regular people just tend to work it out.
Right.
I don't disagree. We don't even have time for child support, Alan. I told you.
I really, next time, Dan, don't.
No, I was just joking. I think this was real. I mean, there's so much we can. I mean, there's really, but it's a given where we're at. I think in our professional careers, we take for granted how this stuff to us is second nature. But if you're getting a case done and resolved, and you get to this stage of drafting agreements, these are the things that you really should consider and should be built into the agreements if you want to have not only a comprehensive agreement, but an agreement that addresses the things that need to be addressed, and you protect yourself as a lawyer too.
And one that doesn't lead to future litigation. That's
I would just keep in mind that no matter how hard you try, I find that there's always going to
Always right.
that you be on. Yeah. There's always going to be something that you didn't anticipate. And just because Dan brought up child support, we talk about what are called in New York add-on expenses, which is over and above basic child support for food, clothing, shelter. So add-on expenses, unreimbursed medical, summer camp, extracurricular activities, private school. Okay. But the list of possible add-on expenses, at least in a town like this in New York City, seems to keep growing, or people's interpretation of what falls under that umbrella.
Right.
And that's something I beat myself up about, because I still kind of go with the traditional, but I feel like, wait a minute, that's an add-on? So like
you're not addressing horseback riding and fencing. Those are the most
just to me, the one that irks me the most is Uber rides. I mean, if you're going to throw that in, I mean, now people spend thousands of dollars a week on this.
Make sure you do your CSSA opt-out. Otherwise, you don't have
cell phone bills, Netflix, Hulu. I mean, it just becomes ridiculous. But I'm just bringing this up to emphasize you're not going to be able to capture everything.
And then there's always the issue of what is covered by regular child support, and what is an add-on. And there's a tendency to move lots of expenses out of regular and into add-on world.
Judge, where are you seeing in the mediations caps for child support topping out at now? Because because of your role as mediator, you're now seeing almost on an everyday basis, I assume, these type of issues and fighting over caps, maybe even more so than when you were on the bench. Where are you seeing it fall out? So like the top?
The top 800. Still remember, I issued an $800,000 decision a long time ago, which was like the highest.
Yeah.
But I still see it not that much higher. 800, 900,000. Occasionally $1 million cap, but it hasn't grown, hasn't tripled since the years I did decisions. Right.
Right.
Yeah.
Well, I keep saying in New York, okay, the highest reported decision is a cap of 800,000.
Yeah.
But yet you see a lot of people in this town throwing around caps that are way higher than that.
Yeah. Right.
So
I think it also depends on what A, incomes, and B, what the add-on expense framework is. I think if private school and nanny and
All the expenses were private school, then the cap is down.
right.
Yeah.
Well, everyone, thank you for joining us.
Do you have any future questions? So I guess
Yes, questions.
Thank you guys. And thank you so much for all of your insights. Just always so great to hear all of your perspectives. We really appreciate that. If you haven't yet submitted your question and you would like to, you can always click the Q&A button and then you can go ahead and send your question in there. We have a couple, so I'll go ahead and get us started. But this first one is, what drafting strategies do you feel help prevent disputes over personal property or minor assets? We kind of talked about this early on, but are there any additional drafting strategies that you'd like to touch on that you've found to be useful in your practices?
Alan?
Go ahead, Dan.
No, you
No, I think you want to be as definitive as possible. In other words, you don't want to leave room open for, well, what if this happens? In other words, let's say there's because if you start using language, they'll try to divide the property with as close to equal value as possible. We've all used that language, but it has a little risk because somebody could say, well, no, that's not really fair again because he got the sofa. That's a killer sofa. So I think, again, when we talk about alternate select, just to the extent you can make it black and white. I mean, again, you can't draft around or anticipate everything, but again, you could really get into the weeds here to say if you're going to do alternate selection, but it turns out that means that one person got 56 items and the other got 57. What do you do in that? I mean, I hope that case never comes to fruition because I don't know what to do. Cut the sofa in half. I mean,
I think
they made I did 2 love seats.
right. Yeah, right.
they all come in parts out today anyway, right?
Yeah,
It got for
what we talked about earlier is just the way through sometimes is just getting, if you have to get granular, unfortunately you get granular, you do the inventory, understand the what is there and what you're actually fighting over so that there's not any ambiguity. And
That's a very good point to just, if it gets to that point, you can literally say wife gets these items and list them. Husband gets these items. And even if it's a long list, that's it. Right.
Awesome. Well, thank you both for that insight. And then this next question is, how should projected income taxes be defined and allocated in asset division, in your opinion?
Yeah, no, you do need a detailed definition, which I thankfully have not committed to memory, even though I use it in agreements all the time. I can't remember it. You're welcome to email me. I mean, this is a definition that I'm sure Dan uses a lot as well. I mean, first you have to define income taxes, then you define projected income taxes, aggregate income taxes. I mean, these are all standard definitions that we use from one agreement to the next. That doesn't mean you just cut and paste because you do need to tailor them to the specific couple sometimes. But
I think, and if you have sensitivity to getting into all the specific legalese, I would default to kicking it to the accountant. Identify that projected income taxes need to be addressed, whether specific to an asset, and then say in the provision that it will be, reconciled, or, appoint a neutral accountant that will reconcile the projected income taxes once they're realized. I think is where I would default to if it's get overly complicated. Just kick it to the professional, and then you've protected yourself and you've also addressed the issue. You agree, Al?
I do. I mean, I think sometimes for whatever reason, divorce lawyers get skittish about getting too into the weeds on how you define that. And so if it just turns out that ultimately you can't agree on that definition, like Dan said, you do have kind of a safe harbor there.
Awesome. Well, I think those are all the questions that we have time for. Thank you again for taking the time to answer our audience questions. And thank you to everyone who submitted your questions. Definitely would love to have a part two. I know there were some things that we didn't get to today, so we'll definitely be in touch. Thank you to all of our audience members for joining us for another Justia webinar. As I mentioned earlier, if you're a lawyer here today, don't miss out on the Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile at lawyers.justia.com to connect with millions of potential clients each month. We also have our Justia premium placements, both gold and platinum, to put you ahead of the competition, which you can learn more about at marketing.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks so much for being here. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.